Hi, my name's Aidan, and today I'm going to be talking about the risks associated with the creation of the Trans Mountain Pipeline in British Columbia. So just to begin, I wanted to talk a little bit about the Federal Provincial Division of Powers. So in terms of the environment and environmental law, there's a lot of competing concerns and difficulties and complexities with the environment. Spills can happen at a local level. They can happen across provinces. Pipelines, obviously, as we're going to be talking about today, are interprovincial entities. There's concerns regarding criminal law and individuals who break environmental regulations and environmental laws, and even concerns regarding how property works and local works within a province. So the environment is a really, really complex area of law. So it's important that when we're looking at the risks, we're analyzing the complexities as well as the vagueness of the division of powers. So just to start, we're going to do a little video that just kind of goes over the complexities of environmental law. So I'm just going to pull that up.
The environmental law is not just about valuing the environment, but protecting it so we as populations live within the carrying capacity of the earth. A better way to think about environmental law is as the law of environmental problems. Some problems are going to be very local, contaminated land. Others are going to be global, climate change. A common feature of environmental problems is that they are both physically complex and socially complex. They're physically complex because they involve ecosystems. If we put fertilizer on agricultural land and it runs off into rivers, a whole range of implications might happen for the natural environment and also for human health. But they're also socially complex. Environmental problems are often caused by a range of different people, not intending to harm the environment, but each of their actions contributing to an environmental problem.
Video that the environment really is a complex area of law. There's lots of competing issues and factors that we have to take into account when we're doing an analysis of environmental law, and particularly with something like a pipeline. There's many competing concerns regarding spills, what's local, what isn't, are national concerns highlighted over local concerns. So when we're doing our risk management analysis, it's really important that we take those questions into consideration. So just to begin, I'm going to talk a little bit about just what the Trans Mountain Pipeline is. So the Trans Mountain Pipeline involves the twinning of the existing Trans Mountain Pipeline in order to increase capacity. And you can see by the numbers there that the capacity of the pipeline is increasing by almost 8 times its current petroleum carrying capacity. And as well, the pipeline is going to significantly increase tanker traffic and shipping traffic in BC waterways. And that has important implications for the residents of BC, for Indigenous groups, and even the ecosystem. So from there, what are the risks associated with the creation of the pipeline? So some of the risks associated with the creation of the pipeline are the potential to violate Indigenous land and treaty rights. So the government does have a fiduciary duty to act in Indigenous people's best interests. And if it is found that the Trans Mountain Pipeline and the National Energy Board hasn't properly consulted Indigenous people, they could be in a breach of their fiduciary duty to Indigenous people. As well, there's concerns regarding potential harm to human health. So if a spill occurs and it gets into a waterway, that can potentially harm the humans who live in the surrounding area, and what legal implications and punishments surround that are important to consider when looking at the Trans Mountain Pipeline. As well, there's the harm caused to Indigenous cultural and subsistence practices. So if the pipeline negatively harms, an Indigenous group's ability to farm or hunt or gather materials, that can again be a breach of fiduciary duty. It can negatively impact the surrounding area, and by negatively impacting the surrounding area, it can harm Indigenous people. And that's not even limited to just food gathering. That can even be just cultural practices. If the environment is harmed, that can have negative implications for the Indigenous people living in the area. As well, there's the international law agreements surrounding the Trans Mountain Pipeline. So Canada is a member to numerous global international law agreements regarding the environment and climate change, and how we create the Trans Mountain Pipeline and the climate emissions and the carbon emissions that result from the pipeline have severe risks associated with them if we break those international law obligations. As well, there's some risk concerning the various uh, concerns regarding promoting economic growth and balancing the wishes of the rest of the Canadian provinces. So in terms of Alberta and British Columbia, there's drastically different competing concerns and values there. So it's important that when we are looking at the Trans Mountain Pipeline, that we're understanding that pushing the law in one way towards maybe a side that is more favorable to BC does have negative implications for Alberta and vice versa. So there's really never going to be an ability to increase or to decrease, sorry, that risk to zero, because there's always going to be competing concerns. So how has the law responded to these risks? Well, the first way that they have through the Trans Mountain Pipeline is the Canadian Environmental Assessment Act, which basically looks at numerous environmental factors and the impact of the project in order to gauge the amount of environmental destruction that can result and who are impacted by the project. As well, the Environmental Assessment Act talks about meaningful consultation, and it's not really clear what meaningful consultation is. In later cases, we'll see that it is defined, defined smaller, or more narrow, I should say, but it's not really clear what that means. There isn't really a test to determine what is meaningful consultation, and that's important when we're talking about risks and how to interact with the Trans Mountain Pipeline, because we really don't know what meaningful consultation is. As well, the federal government has various regulations surrounding interprovincial pipelines, so such as the National Energy Board Act and the Pipeline Safety Act, which the Pipeline Safety Act implements the polluter pays principle, which says that if the National Energy Board or the Trans Mountain Pipeline does cause a spill, or if a spill does occur, it is up to the organization who runs the pipeline to pay for the costs associated with cleaning up the spill. And that extends even to Indigenous groups and people who are impacted by the spill as well. And now we have the Tsilly Nation v. Canada case. And in this case, it was determined that the Trans Mountain Pipeline had to be stopped in its production and moved back to phase 3 consultation, because it was determined that the National Energy Board didn't sufficiently consider how tanker traffic would impact BC residents and failed to meaningfully consult Indigenous people. So with this case, we can kind of see that what meaningful consultation isn't. However, the Tsilly Nation case doesn't talk about what meaningful consultation is. Despite that, though, despite National Energy Board having to go back to redo phase 3 consultation, many Indigenous groups, including the Stolo Nation in BC, are still not happy with the consultation that has occurred and do not believe that they have been adequately consulted in relation to the Trans Mountain Pipeline. So how has BC responded to these risks? So BC attempted to respond to the creation of the Trans Mountain Pipeline by creating the Environmental Management Act. And the Environmental Management Act prohibits the possession and control of increased volumes of heavy oil in BC without a permit. So what this means is that the Trans Mountain Pipeline would have to obtain a permit from BC itself before it was able to bring an increased amount of heavy oil into the province. And this is based on the principle of subsidiarity, which says that certain functions are best performed by the level of government closest to the affected citizens. As well, the province submits that the purpose of the legislation is not to regulate an interprovincial pipeline, but to regulate the release of hazardous substances into the environment. So not the pipeline itself, but merely one aspect of the pipeline. This leads us to the reference of the Environmental Management Act. Canada therefore believes that the Environmental Management Act treads on federal authority over the environment. Therefore, the reference was created to determine the constitutionality of the Environmental Management Act and thus the validity of the Trans Mountain Pipeline's creation in BC. So the main question that the court considers in this case is whether BC can regulate the pipeline in the interests of the environment. So in the Environmental Management Act reference, it was determined by the Supreme Court of Canada that the BC Court of Appeal, in dismissing saying that the constitutionality of the Environmental Management Act was invalid, They agreed with the BC Court of Appeal to determine that the Environmental Management Act specifically targeted the federal government's creation of the Trans Mountain Pipeline. And even if the act wasn't intended to stop the pipeline, the legislation does in effect, prevent the pipeline from being created in BC. So it was determined that it wasn't within the legislative authority of BC to enact the Environmental Management Act as it tramples upon federal jurisdiction. So what are the implications of this? So the court said that the Environmental Management Act couldn't govern the pipeline. So in essence, what's happening here is the court is answering many of the risks posed to the federal government, such as mitigating costs associated with complying with the legislation. They don't have to obtain the permits required. There's no extra environmental or consultative steps that need to be taken by the government of Canada. So a lot of the risks posed to the federal government appear to be lessened. However, the Environmental Management Act doesn't really say that the province has no jurisdiction in terms of the environment, just that this piece of legislation does tread on federal jurisdictions. And that's important when we talk about helping the defects in the law later, because there might be an avenue in which BC can regulate parts of the environment to mitigate the risks associated with the pipeline while not interfering with the pipeline itself. However, the Environmental Management Act reference doesn't talk about the adverse impact of the pipeline on BC residents or Indigenous groups. So there was an opportunity here for the court to talk about both of these two groups, but it's not really clear what BC thinks of them. They don't really talk about them throughout the case. If anything, they bring them up as concerns, but don't really outline tests involved for that meaningful consultation that needs to occur, or how the concerns of these groups will be impacted by BC not being allowed to regulate this aspect of the environment. And as well, the risks associated with the creation of the pipeline do not appear to be mitigated really by the court's decision, but the federal government seems to be viewed as justified in its creation of the pipeline. So the court, in effect, is saying the federal government has done what it needs to do. Now it is not up to BC to regulate this aspect of the pipeline. It's only a federal jurisdiction. So obviously there's some big defects in terms of the law. Indigenous people, as we've seen with the Stolo Nation and some of the above cases, they're still not satisfied with the consultation that is going on. So I propose that Indigenous people are consulted throughout the entirety of the Trans Mountain Pipeline's creation. And I believe that this consultation should conform to John Borrow's view of polishing the covenant chain, where agreements between Canada and Indigenous people are over time reworked, renegotiated to ensure that all parties are content with the results. So what that means is that consultation doesn't just occur in the beginning, middle, and end, or phase 1, 2, 3. It occurs throughout the process, and after the process, it is further renegotiated and reevaluated in order to ensure that all parties are content with the results. And I also think that further negotiation with BC needs to occur, or allowing BC to partially regulate the Trans Mountain Pipeline. So while BC does outline that they agreed to parts of the Trans Mountain Pipeline, it was a past government, but they did agree. The province is obviously not content with the creation of the pipeline. So I think that the way to remedy this is to allow BC to regulate some aspects of the pipeline, including the hazardous materials section. And while it was determined in the Environmental Management Act reference that this was not allowed, I think if the law was changed in such a way so that it maybe only incidentally impacted the pipeline and didn't halt the completion of the pipeline completely, I believe that would make it allowed. And then that would be a method in which BC could regulate parts of the hazardous materials in the province while also allowing for the pipeline to be created in the province. So why would these lower the risks? So I think that when talking about Indigenous consultation, I think that polishing the covenant chain would help Indigenous relationships with Canada, because it would ensure that the government of Canada is less likely to be held liable in the case of an oil spill or another similar mishap that happens in the province, because there has been that consultation that occurs throughout the process and even afterwards. So it ensures that Canada maintains its fiduciary duty with Indigenous people, that they're on the same page. If there's problems, those problems are brought up, talked about, and resolved, rather than just being told, the Indigenous people just being told that this is what's going to happen, and that the indigenous people give input, but that's basically it. Um, so I think that would mitigate the risk because it would lower the or would make sure that Canada maintains its fiduciary duty with Indigenous people, and um, does create this relationship that allows for spills and potential other liabilities to be resolved between Canada and between the Indigenous groups who are impacted. And then I also think that allowing BC to regulate some aspects of the pipeline would ease concerns of the BC population, such as human health and environmental health, um, because it does allow BC to have a part of regulating the pipeline. And through this regulation of the pipeline and the regulation of hazardous substances, BC could mitigate some of the risks that these see associated with the pipeline's creation in the province. And through creating legislation to mitigate some of these risks, hopefully the overall risks, well, in my opinion, the overall risks of the pipeline itself would be mitigated. So yeah, that's my presentation. Thank you so much. Bye.